Hello, welcome to PitchZone, a weekly show where we invite people who have some real insights that are valuable for executives and especially startup founders. Especially today, because today's guest, she will talk with us about intellectual property, patents, and things that are not easily understood by everybody. And joining me for this conversation is Nathan Gold. Nathan, hailing from San Francisco. Good morning, Nathan. How are you?
Super. Good morning to you and everybody online with us today and all those who are watching later on. But yeah, it's a beautiful day here in San Francisco.
I am looking forward to this conversation here with Shalini. We just had a little green room chat, and she's such a tremendously knowledgeable person when it comes to IP and patents, and also a very pleasant person. So let's bring Shalini in. Shalini Menezes, how are you today? Joining us from India.
I am fantastic. Thank you for having me here. I'm looking forward to the chat.
Oh, we all do. And before we really dive in, let's very quickly say hello to our audience that has joined us here live. I'm always happy to see Anthony's name. Anthony, hello and greetings to San Francisco. We have Massimo Peroncelli, and I see we have a couple other viewers online right now. If you want to put your name into the chat so we know who's on the other side. And while you do that, well, let's immediately dive in. Shalini, again, it is such a great pleasure to have you here today. We have met maybe about 1.5, closer to 2 years ago, and I have watched your progress as a public speaker, and I've also always been so intrigued with the content and how you're helping people understand IP and intellectual property protections. Shalini, what got you started with IP? You are very passionate about it. How did this come about?
So today, if you believe it or not, I've spent the whole day talking about IP. So that should tell you how passionate I am. It incidentally didn't start with any kind of passion into IP. I was supposed to be doing my PhD in physics, and I landed in the US with with a free ride, a scholarship, and an admission into a very good university. And the first week that I was in a lab, I was you get to try out each lab that you want for 3 months. And the first lab that I walked into in the first week, the advisor I was working with was hopping mad, and he was so furious. And I was 22, I was young, I was from a different country, I didn't know what went wrong. I slowly asked someone, I said, hey, why is Dr. Caffrey so upset? And it turned out that he had disclosed his invention to his friend, and his friend had got a patent for it and got it published in a very prestigious journal under his own name. And that was the first time I ever heard about the word patent. And I started looking, and we didn't have Google. Oh, we did have Google, but it was very rudimentary in those days. I'm talking of 2000. So I looked up Ask Jeeves, and anyone remember Ask Jeeves?
Mm-hmm.
So I looked up Ask Jeeves, and I got interested. I said, okay, you need to be technically qualified. Okay. So I had some sort of a vague thing. The PhD did not pan out as I expected. So I said, okay, let me take my LSAT. And I took the LSAT in the US, and but I realized that there is no law course, which offers like a deep dive into intellectual property. And I said, okay, then I'm not going to do law. But 2 years later, I was working as a physics professor in Lake Tahoe um, Community College, and I saw this news item that IIT, which is it is the MIT equivalent, right, in India. IIT was opening up a program in law 3 years residential in-house, and deep every semester you get to deep dive into one intellectual property subject. And I was like, this is it. So I quit my job in the US, came back to India, roamed around, backpacked for a while, and then joined law. And and I got hooked. It was love at first sight.
Amazing. So, Shalini, in the startup world that Claudia and I have been spending the last 15 years in, we are always facing startups that they're really worried about the word patent. They don't know what to do about it. They have these preconceived ideas that it's really expensive and they don't bother with it sometimes. So could you just talk a little bit about how you motivate people to take IP more seriously earlier than later? That
Right. I would have to pass on that question, Nathan. Okay, earlier rather than later is not always true. Is not Does not always hold true. Sometimes it's good to wait, and sometimes it's okay to
okay.
not file for a patent. It's okay.
Mm,
And I'll tell you the reason, right? The patents are expensive. The startups are not wrong about that. It can, and especially if you're trying to file in other countries, you're going into US, Europe, the fees can add up really fast and it can drain your pockets really quickly. So in that sense, I would not advise to jump in for a patent without thinking about it. There has to be a strategy. There has to be a well thought out plan, and there has to be a pipeline of things. Like, let's roll it out in this manner. Sometimes patents may not be the answer to your question. It may be trade secrets, which are much less expensive and a longer term. In fact, you can have a trade secret for life, right? Look at Coca-Cola or Kentucky Fried Chicken spice rub. So you can essentially have a trade secret protection for perpetuity, which you cannot do with patents. So patents is not always the answer, and sometimes it's better to wait for your pre-seed funding or a series A round to get someone to invest in you so you can file your patents on some or your IP on someone else's dime. And that
okay.
ends up being a more robust way of protecting your IP rather than burning holes in your own pocket.
Hold on here, hold on. You just said something that is totally news to me. Patent versus trade secret. Uh,
It's
I
a well-known
always,
secret.
well, I'm probably living under a rock when it comes to these things because I was always under the impression that Coca-Cola, the example you mentioned, they have their formula patented. This is not the case. How can they protect, or how does it work? What's the distinction here? Help
Okay,
me.
so the distinction is patent has very stringent criteria. It has to be brand new. It has to be not obvious to someone who's from that field. So if you're looking at, say, a patent for tweaking your engine, Mercedes engine, which will make your car go, twice as fast or twice the mileage that you currently get, the person who is an expert in that field would not be me or your regular garage mechanic. It would be someone who is in the R&D department at Mercedes or one of the other auto companies. So it has to be brand new. It has to be not obvious to an expert in that field, or as we call them, a person who is skilled in the art. And third, it has to be useful, right? It has to be commercially viable. Uh, and also it's only valid for 20 years from the date of application, so there's a limited lifetime. You got to finish, get all your regulations, approvals, all of that sorted. Within that, you need to roll it out, get to the market as soon as you can, monetize before someone else can come in and reverse engineer or come up with an improvement on your uh, invention. So you are stuck in that 20-year time frame. You got to rush things, which may not always work with, say, pharmaceutical products, right? Because those babies are They take a long time to get your FDA approvals, to get your clinical trials on rats, on humans. It just takes a long time. Trade secret, on the other hand, if something cannot be reverse engineered easily, I always advise, in fact, I just finished advising someone earlier today that she should go in for a trade secret. There is no filing with any authority. You just call it a trade secret. You keep it a secret, keep it under lock and key. Don't let too many people get access to it. And you can keep it a secret for as long as you want.
Well, wait a minute now. Hang on a second here, Shelly. This is blowing my mind as well. Are you meaning to tell me that here in the United States, I could say that I have a trade secret right now? I don't have to document it anywhere. I don't have to file it anywhere. And
You
then
have
I
to,
can use that? Go ahead.
okay, it has
I'm
to be written.
confused.
Yeah, okay. So it has to
Okay.
be written and kept under lock and key or password protected.
Okay.
And that's it. And you say it's your trade secret. The only thing is, it should actually be a secret. It shouldn't be something that's known to everybody, and then you calling it your secret. Won't work.
Right.
But you can have anything as a trade secret. You can have a recipe. You can have an algorithm. Google search algorithm is a trade secret. New York Times bestseller list is a trade secret.
Okay.
Um,
Okay.
Kentucky Fried Chicken spice rub is a trade secret. So
All right. All right. Wait, hang on just a quick second here. Claudio, I have to ask Shalini to do this. This is one of the most eye-opening point distinctions I've heard around startups in forever. So please, I would like you to just talk a little bit more so I can get my head straight to coach people in the future. When they're crying about how expensive patents are, I want to tell them, okay, don't worry about patents for right now. Go trade secrets. So what do I tell them to do?
okay, so the test is, can it be easily copied and reverse engineered?
Mm-hmm.
If it can, then go patents. If it cannot, then leave it as a trade secret. And
Okay.
I'll tell you the reason. There's a logic behind it. The reason is that the moment you file a patent application, it gets published in 18 months. The moment it gets published, it's free for everyone in the world to see, right? Which means I can, let's say Claudio files for a patent in Thailand, and 18 months later it's published, I can log in to Thailand patent office, check out Claudio's invention, and reverse engineer it in India. He cannot do anything about it because he doesn't have a patent in India, right? So if it can be protected, if it can be easily reverse engineered, file in as many countries as you can and protect it. But if it cannot be copied easily, if it cannot be reverse engineered easily, then go in for trade secret and keep it that way. It will get you economic benefits for much longer than a patent can, at much less cost.
Wow. This is truly, truly news to me. And I'm curious, looking at Nathan, this is news to Nathan as well. And I'm curious about our viewers online. Is this news to you? Did you know that you can declare something as a trade secret and it's almost as powerful as a patent? If you knew, put in yes into the
Yeah,
comments. If
I'm
not,
eager
then
to
put
see
in
how many
no.
new.
Yeah,
I'm eager
I'm
to see
You know,
how
I
really.
have
many.
heard of
Yes.
I've heard of trade secrets my whole life, of course, but I've never looked at it the way you just broke it down. That
See,
you gave
because,
totally new meaning to this
and I'll tell
distinction
you the
between
reason. When we
patent.
say, I'm sorry, when we say intellectual property, the first word that crops up into everyone's mind is patent, and then maybe trade secret, and maybe copyrights. But there's a bigger world out there. There is trade secrets, there is industrial designs, there is geographical indications, and lesser known form is a biodiversity act where we try to protect flora and fauna, and plant variety protection. So there are all these things out there, and it's very unfair to say intellectual property is patents, and I think that's the most popular one we all know.
This is so interesting. And Massimo, he responded to our question. And Massimo, he ran a book publishing house in Italy. So he's very, very familiar with, what the book publishing and more like the copyright kind of things. But he makes, or he lets us know here that in Italy, to protect your non-published book, send it to yourself as a registered letter and don't open it. And then if somebody is copying your work, you go with that unopened letter to court and you will win. So thank you for that information, Massimo. That's very, very interesting. And one thing, Shalini, that you mentioned before, and this is also where I have a trouble right now getting my brain to wrap around this. You mentioned that the New York Times bestseller list is a trade secret.
Right.
How? I mean, what's secret about it? And if I'm the New Yorker, right, and I want to do a top 10 or a bestseller list like that, would that prevent me from doing that? Help me
Okay.
unwind my brain here, because you are the one that put it into knots now. So
Yeah.
unknot my brain.
I'll tell you. When we say New York Times bestseller list, what is the first thing that comes to mind? That this book must have sold so many copies. Like the one with the most copies sold wins. But if that was the case, then publishers and booksellers would start rigging the system. And so New York Times has an algorithm. Obviously it's a trade secret, so I don't know what goes into it, but it's not just how many copies get sold. And the weird part is books get selected as the number one on the New York Times bestseller list even before they're published. And that's crazy, but I don't know how they do it. I tried to find out as much information as I could. But that's all they said, that it's not just the number of copies. It's not that. So, and so to
Amazing.
answer your next question, there is nothing stopping you from coming up with your own list. Just as long as, New York Times doesn't think that it's exactly somehow you've committed some kind of corporate espionage and stolen their trade secret, then they'll come after you hammer and tongs. But otherwise, you're free to come up with your own algorithm, your own trade secret.
Wow. I'm so happy that you're here today, Shalini, because I am learning with every minute something new here. Absolutely
Yes.
fabulous.
Claudia, let's take Anthony's question because I think it's a really good one, and that is, how do you protect a trade secret in a court challenge if the content has to remain secret?
That's a very good question. And usually, I think these proceedings are held in camera in a closed chamber with restricted
Oh,
access. They don't allow media and anyone who's not connected to the case to be in there. That's how it happens in India. And I think that's how it would happen in the rest of the world too, because you want to limit access to what is the secret, as the question says.
I want to, before we continue, very quickly welcome Yash as well. Yash, thank you for joining us here from India, and no problem about being late. This is how these things go. But usually when you're late, you're bringing some cookies for us or something like that. So just for next time, Yash. All right.
Yash lives closer to me. I think he can pass those cookies to me.
There you go. So this is really, really fascinating, Shalini, and I'm glad we had this discussion about trade secrets versus patents. Can you go and search your database, your internal database, for some case studies about intellectual property protection? I'm looking for, do you have an example of a company that did it really, really well? And then, of course, an example where it didn't work out all that well. And I know you are full of stories like this. So, Shalini.
So companies that did well, didn't do well, intellectual property. Apple is always going after someone or the other of their employees, ex-employees, for corporate espionage and for trade secret protection. I think a few years ago, Intel also had a couple of employees who left and took their trade secrets, some kind of software to a rival company. So industry is rife with these things. But what I want to talk about is this concept of intellectual property, right? We When we say intellectual property, the definition is it's a creation of your mind, right? Property from the intellect. Now, would it make sense to say that only humans have intellect?
Mhm. Mhm.
Property, when we talk of property, this concept is a very human concept, right? Dogs, cats, monkeys, they don't care about property, right? They just find a bone, they dig it, and then they're done with it. And but there was this case in court a few years ago where there was this wildlife photographer called David Slater, and he was trying to get the picture of this particular monkey, okay, macaque monkey. And the monkey was, though that particular species of monkey is very reticent, they are shy, they don't like to be seen by people. So what he did, he took a bunch of those disposable cameras and littered it all around the place where the monkeys like to go and hang out. And one of these monkeys was playing around with the disposable camera, looked at it, and clicked a selfie, and then threw the camera. A couple of days later, David Slater went back, picked up all the cameras. When he developed it, he got a spectacular picture of the monkey, and I'm sure if you look it up, you're going to recognize that picture. It is this monkey with grinning at the camera, right? If you go to Wikipedia page of that monkey, it's Macaque. If you go and Google it, that's the picture that is there. So Wikipedia. So David Slater was advertising, and look how brilliant a photographer I am. So Wikipedia took that picture and put it in that spot where it usually you have an image of the subject, right? David Slater sued Wikipedia saying, "Hey, that's my intellectual property." Now, here's where things got interesting. PETA, which is the Society for Ethical Treatment of Animals in the US, stands up and says, the picture was a selfie taken by the monkey. We are the guardians of all animals, and therefore the proceeds from the sales go to us. Believe it or not, this case went to court.
Wow.
And for nearly 2 years, the courts couldn't decide which is the right jurisdiction. Should it be the US because PETA and Wikipedia are from the US? Should it be the UK because David Slater is from the UK? And finally, they settled on the right court. And finally, the court also held that David Slater, the copyright belongs to David Slater, but some proceeds will go to Wikipedia or will go to PETA for the welfare of animals. Now, look at the strange nature of this case, right? What is an animal going to do with property? What is an animal going to do with intellectual property? The whole point of intellectual property is that it's an asset, right? We buy property, we buy land, we buy a house, we buy computer because it's going to give us some benefit. We're going to sell the house on a rainy day, or we're going to live in it, we're going to give it to our kids or whatever. What is a monkey going to do with money? So there you have it. I mean, the cases are there are and as you know, in the last few years, such cases have evolved. There are more cases like this than lesser. There is also a case of a man who created a robot, and that robot invented something, and the South African court awarded the patent to the robot. So the robot became the inventor of the patent. So this is a hot topic in intellectual property. Should AI be allowed to own intellectual property, or can intellectual property be awarded to AI? So, for example, if you have Mid Journey and you give it a prompt and Mid Journey creates images, whom does the copyright of those art forms belong to? Does it belong to Claudio, who gave the prompt, or does it belong to Mid Journey, or does it belong to the software or the person who created the software that is Mid Journey today? So it's a tangled mess right now. We don't know where we are. Some courts give intellectual property rights to AI. Some courts say no, we don't agree. And it's ultimately still the human intellect which is at the core of these creations. So let's see where things go. It's an interesting time to be in.
This is a perfect time to have you maybe take this question that is burning in my mind, and that is, with all of what you just said and AI and robots and everything going on, whether it's a hardware robot, a software robot, where do you see, or how do you see IP changing or morphing now over these next 5, 10, 20 years based on where it's been for the last 100 years, let's say?
So when I started studying IP, everything was pretty much set in stone, and we didn't ever think
Mm.
that things would reach this point. I don't think anybody
Mm.
at that 20 years ago had the foresight that it's going to turn out this way. But right now the boundaries have kind of disintegrated. We don't know what is whose property, especially with Bard and Chat GPT and all of these AI related AI
Mhm.
chatbots and programs. We don't know. Like I can give a prompt. So I tried this experiment, right? I tried to give a prompt to Chat GPT and asked it to write me a sonnet. It wrote me a sonnet, and I said, I logged into another computer and I gave it the same prompt, and it gave me roughly the same sonnet with just said in a different manner. So, but there are cases filed against OpenAI, right? Because all of these things that have been fed into the computer to for the machine learning belongs to someone else. There is Shakespeare and there's Milton and Keats and Newton and Einstein. Everybody's books are there that have been fed into the system, which is being
Mm.
regurgitated out to us. So
Mm.
the lines have I don't know, they are very blurry right now, and we don't know where we stand.
Almost sounds like a great time to get into IP because so much is changing, and maybe it's not as boring as I used to think for the last 50 years.
You
It's
just
getting
don't.
exciting.
It's very exciting times to be in, especially
Yeah.
since up until recently a lot of courts said that we don't understand computers, computer related inventions, pure software cannot be patented. No, but now a lot more courts are will patent offices and courts are willing to examine computer related inventions, grant patents to computer related inventions, softwares even. So
Yeah.
yes, things are changing. And but the problem with law is, it cannot keep up with technology. Technology is a jaguar. It's like far ahead, and law is this doddering old person walking behind at snail's pace, saying, I'll catch up with you. You go ahead." And yeah, I hope law would move faster, but it doesn't.
Well, don't you think they'll be forced to based on the cases that are going to go through the courts when all of this stuff starts getting used? The judges and the juries are going to be faced with either
So
adopting the current laws that are available to make decisions on, or they're going to have to make new ones. Anyway, yeah, what a mess.
yeah, so what happens is, you would think that the lawmakers would make the law in consonance with the way technology is evolving, but it ends up that the cases go to the judges first. The judges make up, based on this case we are going to analyze it this way, or this case becomes the governing authority for all of the matters that are related to this branch. And then
Mhm.
many years later the lawmakers decide to set it in stone, or get a law out of it. So that's how.
Wow. Wow, wow, wow. I can't wait to see really how and where all of this is leading, and we might have to invent a couple new lawyer jokes into the future as well. So, Shalini, again, you are a treasure trove of information and knowledge about intellectual property and patents. Our audience, if you want to get in touch with Shalini, her website is patented.network. Again, that's patented.network. And this is actually a very unique idea that you had here, Shalini, with this concept. You came in an earlier episode of PitchZone a year ago to actually do a practice pitch about that. Tell us a little bit about what exactly this network is about and how did you come up with it?
So there is this company called Ocean Tomo in Chicago, and they had started out in 2006 or 2005, which was the same year I got into law school. So I was fascinated with them, and I really wanted to do that. Whatever they were doing, I didn't know then what it was. It just looked very glamorous and very exciting. And I kept telling all my classmates, let's work together. Let's start something. Let's start valuation. Let's start commercialization. I didn't know what any of it meant at that time. And obviously they knew that I didn't know anything, and they didn't know anything either. But they were wiser, they were smarter, and they said, no, we don't know anything. I don't think we should work on this. And I said, yeah, but let's learn, let's figure it out. But those days you didn't have so much information on Google as you do today. Again, uh, I don't know, I had this concept, but life happened, kids were born, I went back and forth between the United States and India, and various parts of India. And Nathan and I also lived in San Jose for a bit, and Lake Tahoe, and all along the coast of California. So it happened, and then pandemic happened, and we all suddenly had so much time on our hands because we weren't driving around between school and classes and client meetings. And I said, this is the time. And I had just started my PhD in valuation of patents, valuation of intangibles. And I said, I'm going to start. And I don't know, people thought it was a crazy idea. They said, nobody's going to buy patents from you, and you're going to be broke. And it's true, nobody has bought any patents from me. It's been 2 years. They're not wrong, but valuation. I have about 100 patents on my site, and I want to make it like you go to GoDaddy, you pick up a domain name, and with that GoDaddy says, here we can host it for you, and we can give you WordPress, and we can do connect it to your email, and we can do this for you and that for you, and pick up the bundle for this much. And that's the vision I have for patents. Like, you come pick up a patent, we'll give you inventor support, we'll give you company incorporation, trademark, and put you in touch with someone who will look after your company, company regulations and compliances and stuff. And it'll be business in a box. You give someone a gift box, and they open it, and like the entire business is in there. And I don't know if that's going to work or not, but it's a pipe dream. It's a dream I have. But we are doing valuations and across the world, and it's very exciting because each time you do valuation of intellectual property, you get to learn about the technology. You get to deep dive into it. You get to learn everything about how the market is, and how the world market is, and how the local market is, and what is the future, and how can we project what the future is going to look like, and therefore it costs this much today. It's fun. It's an amazing, thrilling ride, actually. uh, and people do reach out, and what I do is, I don't tell them that if you post on my website you can't do anything else, I'm going to be the only one. I'm like, no, the idea is we need to sell patents. The idea, only 5%, okay, only 5% of the world's patents are commercialized. So out of the 95%, even if I say 50% are, silly patents, you have a patent for a leash to walk your pet snake. I'm not kidding. There is a patent for that. There is a patent for a toy to exercise machine for your cat, which is essentially a laser pointer. And so let's get rid of 50% of that. I still have 45% of the world's patents that are there that could be sold to someone who needs it. So my thing is very simple. My pitch is, you try to sell it on your own. I will try to do my best on your behalf. Let's see who gets there first. So I get into a lot of interesting conversations. I get to talk to the VPs of companies. I get to talk to the R&D heads, And the good thing is they come back and they tell you why they cannot buy it. They come back and they give you a reason. Some ghost you, of course, but some do come back and they have a nice chat with you for an hour or two and tell you, what was wrong with your pitch, or what was wrong with the, maybe not wrong with the pattern, but we are not in the right place at the same time. So it's nice. The conversations are fantastic.
Yeah,
Oh,
incredible.
this is really, really good. And Shalini, I'm sitting here and I'm watching you, and you are such a natural and really fabulous, polished. Well, not polished, but natural and authentic communicator. You have a presence here on screen that is way above average. You haven't always been this way, right? When we met 2 years ago, I looked at Shalini and I said, wow, there is so much potential. It's a diamond in the rough. It's a diamond in the rough. In the meantime, you are a well-cut diamond. Tell us a little bit about your journey, because this show, of course, is mostly about presenting and presentation skills, and our audience is definitely interested in knowing, how did you get from shy, reserved, and lots of butterflies in your stomach, to today confident, calm, and still lots of butterflies in your stomach? How did you do that?
The butterflies never go away, and I think I have amazing people in my team, like yourselves and Martin Barnes, and a number of people from Pitch Club and Pitch Zone put together, who have helped me get to this point. I am still shy. I'm still reserved. I know you don't believe it, but I will go to any length to avoid a phone call with someone I don't know, or a social gathering which has more than three people. I will go to any extent to avoid it. But having said that, I'll tell you my journey. My first foray, my sister was also shy in school, but she started public speaking when she went to college, and she was a natural. And I thought, why don't I start in school? So I gave my name for an elocution competition, and when I was in seventh grade or eighth grade, and my teacher said, "You are so boring. You're putting me to sleep." And I gathered up my papers. I came home and I cried my heart out. And then I said, okay, I will write. So I started writing. I started writing poetry, and then I started writing all sorts of things, funny essays and letters, love letter to a mitochondria, and all sorts of goofy things. And I evolved as a writer, but my speaking skills were still terrible. I had a couple more such instances where I went on stage, I forgot my speech, I had learned it by heart, and it was. I took public speaking classes, but that didn't really help me much. I don't know why. There were some very good public speakers in my class, and I had a great teacher, but I was 16, I was 17, maybe I was not in the right frame to learn about how to present. I think the student has to be open to learn too. So while this was there, this wasn't there. And I went abroad. When I went to the US to study, I got a teaching job, and I had to teach a classroom full of freshmen. And there was a language, there was a cultural divide, there was pretty much a language divide. Even though we both spoke English, I had an accent and they had an American accent, and it was. But by the time we were at the end of 2 years, I got made the person who supervises all the other TAs. And they wanted to make it a full time job, but I wanted to graduate and leave university. And I got a job as a physics professor. I taught, I used to teach 9 hours in a day, back to back physics, optics, physics, optics. When I started intellectual property, again, it was one of those things. I started talking, and I realized that the trick was to know your subject matter. That's half the battle. Of course, there are nuances. There is There are nuances. How you're looking at your audience, how you're presenting your hands, breathing, pausing, all those things. They are the finer points, right? But I think the key to it is knowing your subject matter, and which is what I tell my son too. He's 15, and he was upset that he didn't get into. He got disqualified because he wasn't a good speaker. And I said, got to know your subject matter. If you know it, you feel it. That's half your battle. And and then of course for the finer points, I used to. You won't believe, I was a member at Pitch Club with Martin Barnes, and I just that it was 11 p.m. my time when he used to have it on Thursdays, and I used to stay up every Thursday night for nearly 5 months in a row. I was groggy, I was half asleep, but it was like 11 to midnight, and I stay up, make my pitch, 3 minute pitch, and then I would get all kinds of feedback, and I would write it down, and then next week I would go back there and present, and again get feedback, again come write it down, and work on it. And I didn't spend so much time on the material as I did on all the other things, on the presentation techniques from Andy Churchill. And then I met Claudio, right? Claudio and Nathan, and I came and pitched here a couple of times. So all of those things have really helped me. But I think the important thing is to know that you need to change. The important thing is to know that you have to improve. If you think you're the best, you're not going to improve.
Okay, Shalini, we're almost out of time here, and I have one burning question that I know many of the audience would love to hear, and it's a little bit selfish, but seeing your journey over the last year or two, going from somewhat shy to who you are today, and even though you might still feel it's not all you yet there, you sure showed everybody today that you are one confident person. What one tip could you offer other women that you learned in your journey to where you are today that might help them today?
Show up and ask for help.
Oh, I so love this. And actually, this is not just a great advice for other women. I think this is a great advice in general. People are so shy to ask for help. Wonderful, wonderful advice. Now, Shalini, we are really nearing the end. So this answer, maybe a minute or so, but maybe it will be as short as the previous one that we just got. I'm really curious, Shalini. In your moments of doubt or challenge, what's one mantra or a belief that has always kept you grounded and helped you push forward?
I've been in worse situations before. I'll get out of this one. And I have. I've been in terrible situations. Uh, and I don't want to ruin the mood here, but I wouldn't wish it on anyone. And so I think I have it in me. Whatever the situation is, I don't pray. I am an atheist. So I don't. So people ask me, but how do you live through troubled times without praying or without relying on someone? Because in the end, no one is going to come to save me. It's got to be me. And that aha moment was when I had kids, and I was like, who's going to look after these kids? Nobody. Who's going to look after this thing that's crying in my arms? And I realized nobody. It's got to be me. So I said, you know what? If I can do it for the kid, I can do it for myself. So there you go. I'm going to say one more thing. I'm going to go back to Nathan's request for my advice to women, and I'm going to say I can't advise women in isolation. And there are a lot of people I've alienated here in Goa because of that mindset where they call me on women's committee and say, advise these women, advise those women. It cannot be done. We have to advise. Men and women have to be trained at the same time, because women don't live in isolation. We are connected to husbands and fathers and brothers and sons. And at the end of the day, if we go back and they are not emancipated and we are, it's going to do us a fat lot of good. So we all have to get emancipated or improve together.
Wow, Shalini, what a perfect way to end this program here today. Value from the first moment on until just now. Thank you so much, Shalini. Thank you, Nathan, for making this another engaging session here as well. And thanks everybody who joined us here again today live and everybody who's watching the replay. And with that, I wish you all a wonderful morning, afternoon, evening, wherever you are in the world. And we shall see each other again next week. See you. Bye-bye.